The defense counsel for Carmelo Anthony made much ado about the weight difference, and this is where the proportionality comes into play here. I think that the young man who was murdered, he outweighed Carmelo Anthony, the murderer, by 60 pounds. So the defense counsel really tried to harp on that. And I don't think that carried weight with the jury. Does that particularly, pun actually not intended, does that carry weight with you, Chris? So
I certainly think it's a factor, but again, just because somebody's big doesn't mean that they're threatening, doesn't mean that they're intimidating. Even again, if he is coming at you, it's a factor. I certainly understand bringing it up, but if he's not saying, hey, I'm going to kill you, or if he's not doing anything that otherwise indicates that your life is in danger, just the fact that he was a bigger guy clearly didn't carry any weight with the jury.
welcome to episode 126 of the Weekly Docket, a podcast by the Silberman Law Firm where we talk legal news and practical law. It is June 11th, 2026. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Hill, who's our firm's supervising attorney. Chris, how are you doing today, my friend?
I'm doing well. I'm doing better than 2 million Spurs fans.
I know I fell asleep last night and I thought the Spurs had it and it did not work out, I understand. So
You would have been right 999 times out of 1,000.
that's why I'm not a gambler. So, all right, today on our docket, we're going to talk about how do you remove minors from deeds? And then we're going to talk a little bit about the Texas track meet trial stabbing. We're not going to go into huge amounts of detail on that. We're going to be mostly talking about the use of deadly force in Texas under the penal code. And then finally, we're going to be answering a question about contractors and whether or not you can hire a new contractor when your current contractor decides maybe he's abandoning the project or something like that. So let us get it kicked off with our first question. How do you remove minors from deeds? And first answer to that question is the obvious thing, capacity. Minors don't have legal capacity in Texas. So you can certainly deed a property to a minor, but having the minor sign their interest away after that is not so possible. It's kind of like a one-way street.
Deeding property to minors is not advisable. So most of the time you encounter this, it's when the minor inherits property. If you deed property to a minor, that's not a good decision. Don't do that. Just don't do it. But yeah, if a minor holds title and you say, oh, well, I'm their parent, we need to sell, and their interest isn't very much, but they are still an interested person. They do still hold an ownership interest. Can I just sign on their behalf? Or can they sign even though they're 16? And unfortunately they cannot, but the Estates Code does provide a procedure. It's fairly simple, where you just file an application with the court saying, hey, this is how much the minor's interest is worth. We're going through the title company. This is what the property's worth. Can you just okay the title company to sell or to run the transaction? And they'll deposit the funds in the registry of the court. And then when the minor turns 18, they just go to the clerk, fill out a form, and get their money.
Yeah, never a good idea to deed a property to a minor. We do get that question all the time from people, calling up. I think they think it's some sort of maybe asset protection type of mechanism or tax advantage. I'm not sure where that came from, probably TikTok or some urban myth type stuff, but never a good idea. If you happen to have a property already in the name of a minor, there is a process under the Texas Estates Code, Chapter 1351, to sell a minor's interest, but there's strict issues with that. The minor's interest has to be worth $200,000 or less. So if they own a $400,000 home, then it's their interest is, and they own half, then their interest is less than $250,000 or $200,000. So it qualifies. Got to have a parent, or a court appointed conservator apply. here's a catch. You need an active buyer. So you actually have to have the buyer in waiting for the transaction to close. And the court has to find it's in the minor's best interest, which is generally somewhat of a low standard. And then Chris, like you were talking about, the money goes into the registry of the court, and then the parents just don't get the money. That's another big catch. The parents usually will say, now let me just use the money. It doesn't work like that. The minors, it stays there until the minor's ready to get it. So, and then the code specifically says the minor can't void the sale once they turn 18. So, that's one way to do it. There's another way to do it, Chris. If the interest is over 250,000, then you're going to have to do a guardianship of the state, and that's a much more involved process. They model that in long-term burden, where you have to do annual accountings and make sure that you're not just spending the minor's money on bad things, right? It's got to be really all the receipts have to be kept and spent on the minor. So, anything you want to add to that, Chris? Or you think we covered that pretty well?
Well, and I think you did touch on it. The funds are still the minors, so you can't go get a guardianship and say, okay, these are the minor's funds, but they need a guardian because, I need to spend money on them. As parents, it is the law. We have a duty to support our children. So we cannot use their money to support them. We actually are required to spend our money to support our children. So, if they're a special needs child that, needs the funds for extraordinary care, that would be a circumstance where the guardianship would be appropriate. And the court's going to approve you spending the minor's funds. But if they're not incapacitated and don't have special needs, your best option and your simplest and cheapest option is just do the application to sell, have the money deposited with the court, and when they turn 18, go get it, because you're not going to be able to use it in the interim anyway.
Yeah, exactly. So, all right. Well, then that concludes that legal question. Let's go ahead and move on to sort of a legal news piece here. Mostly a legal question. We're talking about this track meet stabbing, deadly force. You'd have to have been living under a rock, I guess, to not heard about this. This occurred in North Texas in our home state. Young man was at a track meet and got into an altercation with another young man. Undisputed that he was pushed, right? And then in response to the push, Carmelo Anthony's the young man's name. He stabbed the kid who pushed him right in the heart, and then the kid died. And he was just convicted in Collin County, which is a county where we practice a lot, of murder. Plain and simple, it was murder. It's just a tragedy all around for the young man and the family who lost his life, and for the young man who did the stabbing and is now going to serve. Well, he's sentenced to 35 years. I understand that he might be paroled at half the time. I think is correct. So. But without going into too much of the politics behind it, and there were a lot of politics behind it, and sort of race accusations, because the boy who shoved was white and the kid who did the stabbing was black. Let's just talk about deadly force, Chris. And this is, in my mind, a public service piece for all the young men out there, and for all the young at heart, right? That don't have good decision making. If whatever context you're in, and let's just say I'm at a Boston Red Sox game and I'm an Astros fan, and the Boston Red Sox fans are notorious for being unruly, right? If I am at a Red Sox game and I get shoved, and we're assuming this is Texas, by the way, even though it's a bad example, but I can't just stab them. And the idea is that under the Texas Penal Code 9.31 self-defense, you're only justified in using deadly force to the extent it's necessary, right, to protect the other's interest. So you can't meet a shove with a stabbing. That's kind of the law on deadly force. Chris, was that something that was obvious to you as an attorney? Should that be obvious to everybody?
Uh, I think everybody should know. Does everybody know? No, of course they don't. And there's a lot of people that probably do take that to the extreme and they say, Texas is a stand your ground state or something like that. And I'm justified in doing this. And hey, maybe you are, maybe you're not. But, first thing you got to think of is you're putting your life in the hands of jurors. Okay. You need to convince those jurors that you feared for your life. And so if there's 5 Red Sox fans that are cornering you and they're coming at you and you're really in fear that these 5 guys are just going to, do significant bodily harm to you or kill you, and you can convince a jury of that, then you're justified in using deadly force. If you're in the stands and there's pushing and shoving, good luck convincing a jury that you felt your life was in danger and that you were justified in using deadly force. So it's not this simple analysis where you can just claim self-defense all the time. You're really putting your hands in your life in the hands of the jurors, and you're going to be charged with convincing them that you really did believe your life was in danger.
I think that's an accurate summary of deadly force. You always hear young people and all sorts of people, say things like, don't put your hands on me. I told him not to put his hands on me, and he did it. And I think that's what Carmelo Anthony said maybe when he was arrested initially. And I just want to point out, having someone put their hands on you is not an excuse for the use of deadly force, even though I think in popular culture and urban settings, almost like a machismo kind of thing, like it's completely inappropriate for anyone to put their hands on you. And I imagine you could create a situation where someone was so large and so physically threatening that just the act of the hands maybe around your throat and he was choking you, that's a type of deadly force that you might be able to respond with a knife or a gun or a baseball bat, but certainly not a shove. And that was really the prosecution's point the whole time, is you can't meet the shove with a knife or a gun. So
yeah, I think if someone shoves you, you can shove them back. You can hit them, and then the hit leads to something else and maybe it gets escalated. But, hopefully that doesn't happen. But yeah, it is the classic, exactly what you're saying. Go ahead, touch me, watch what happens. Right. But just the mere act of one shove or one touch does not then immediately open the floodgates to your use of any amount of force you choose. It still has to be, in line with the force from the other person, which, like you said, could be tough. Like, how am I supposed to evaluate this if this person's starting a fight? I have to have my legal definitions in my head as this fight is escalating. But
the defense counsel for Carmelo Anthony made much ado about the weight difference, and this is where the proportionality comes into play here. I think that the young man who was murdered, he outweighed Carmelo Anthony, the murderer, by 60 pounds. So the defense counsel really tried to harp on that, and I don't think that carried weight with the jury. Does that particularly, pun actually not intended, does that carry weight with you, Chris? So
I certainly think it's a factor, but again, just because somebody's big doesn't mean that they're threatening, doesn't mean that they're intimidating. Even again, if he is coming at you, it's a factor. I certainly understand bringing it up, but if he's not saying, hey, I'm going to kill you, or if he's not doing anything that otherwise indicates that your life is in danger, just the fact that he was a bigger guy clearly didn't carry any weight with the jury. And I think I read that the jury was only out like 3 hours. In a murder case, that's insane, because that means that's extremely quick. Knowing what's hanging in the balance, knowing how big of a deal the decision is. I mean, that just means that they were not convinced at all.
Yeah. There was a track team tent, and Carmelo Anthony was apparently pushed out of the tent. And yeah, it was less than 3 hours of deliberation. And I don't think that the jury really thought that, being pushed out of a tent would necessarily give rise to the use of deadly force. And I think the defense counsel for Carmelo Anthony tried to make it seem as though he was being ganged up upon, and I think the witness testimony just did not prove that out, and the jury, decided that this was just simple murder. So, and here's something interesting, Chris. Under Texas law, you forfeit the right to self-defense if you provoked the difficulty. So if your own actions or words were designed to cause the other person to attack you so that you could use force, the law views you as the aggressor. I'm not, to some extent that came into play here, because the defendant, Carmelo Anthony, allegedly said, touch me and see what happens. So, statutorily, if you dare someone to put their hands on you, you can't use Chapter 9 as the shield when they take the bait. I wasn't aware of that. Chapter 9 is
I think you have to like draw the gun. I have to draw a gun on you, and then you're coming at me. And I say, oh, I feared for my life because Phil was going to take the gun from me and shoot me. Well, you caused that danger. If I say, come at me, Phil, you do not now have license to murder me, and I can't claim self-defense. Saying come at me means, okay, we can have a fist fight. I'm ready to go. I don't think that me saying come at me automatically allows you to then use deadly force on me. So I still think there's always that balance.
Here's something I didn't know we had codified in Texas under the penal code, but apparently words alone are not justification. That's 9.31B1. And the law explicitly states, verbal provocation alone never justifies the use of force. I'm a little bit surprised that we had that. So I guess someone could say, I'm going to kill you, and that alone would not justify the use of force. Is that how you interpret that?
I don't know. That's not how we're to everybody listening, we are not criminal lawyers. We are just talking about this. We did take criminal law in law school. I don't know. That's not what I took it as. I took it as I can't insult your mother. I can't insult your wife. And you say, oh, well, you talk about my wife like that. That's what's going to happen, which is what you'd expect to happen. But I think if I said, I'm going to kill you, then, back to our baseball analogy, if some guys are approaching you in a dark corner and they say, oh, we're going to kill you, I think you can reasonably fear for your life at that point. I think you have to wait for them to attack you. I think you're justified in thinking, oh, okay, these guys are going to kill me.
Yeah, that makes sense. It goes back into the analysis of, did you have a reasonable belief as a prudent person that they were really, deadly force was going to be used. And I think, as you come at someone with a baseball bat and say, I'm going to kill you, that probably rises to that level. But if you're just sitting around the bar and say, hey, you start telling your mama jokes or whatever, that doesn't give rise, right? So,
no.
All right. Well, let's talk about something now that we do actually know about, and that's real estate law. Here's the question we had come up in the lawyer chat room. If the general contractor refuses to perform under the contract, can my client retain other contractors to complete the work on the real property? I mean, right away, So your contractor says, hey, I'm gone. I'm not going to do it. We're done. Can your contractors come out and other contractors come out? Chris, what's your off the cuff response to that?
Yeah, of course. It's just never that easy. They never say, I'm done. They say, I'll be back next week. Or they say, I need more money. And then the person who hired them says, well, you're not doing a very good job. Or, you don't get another draw until phase 3 is complete. And then there becomes a dispute and then they stop showing up. If it were ever as easy as them saying, I quit, I'm out of here. I love that case, but it's never that easy. There's always a dispute over whether their quality of work is good enough, whether they're entitled to payment. And then you got to go hire someone else. And you say, well, their work was so bad, I had to hire this person and this is how much it cost. And the contractor's defense is, oh, well, they overcharged you and my work wasn't bad. I was ready to finish. You were just, too difficult to work with. You had complaints about every single thing I did. So we get these a lot, as you know. So at least we both stop.
I think you're right. The contractor just never says, I'm done, I'm out of here. If he did, that would bring up your favorite topic, Chris, which is anticipatory repudiation.
I think that's your favorite topic.
I know. Which is just the idea that the contractor is obviously repudiated under the contract. He said, I'm not going to do it. So he's obviously breached. Now you don't have to perform. You can go out and hire other contractors. Practically when this happens, what I recommend is, hey, look, document where the work has stopped, because that's going to get your damages component sort of proved up, which is, what did this guy do? Where was he in the process? And really document kind of where the progress was, if any, and then go ahead and send the contractor a clear termination letter and say, hey, look, my allegations are you breached the contract. I'm terminating the contract because of the breach, and my performance is excused, and I'm going on to complete the project with my own contractors. That way, if you do get sued by the contractor that you terminated, you can clearly say, here's what I paid you, here's where the progress stopped, and here's what you were owed. And you might even have other contractors come on and sort of do evaluations at that point, in case you need some reports or some witnesses as to where that contractor stopped. So that's the best practice on that. So, okay. Well, I think that brings our show to a close. I've been your host, Phil Silberman. Chris Hild has been my co-host today. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great rest of your day and week.